Welcome back to the Andy Hale podcast, everybody. Today we're going to be talking about the Starved Rock murders. I'm so excited to have Whitney Braun back. Whitney, hello.
Hello.
Good to see you.
It is good to be back. I wish that I was back under more joyous circumstances, that this conviction had been vacated and we were now, planning a celebratory, tour around the country. But
I'm with you.
I'll take any opportunity to keep talking about this case.
Well, today I want to basically talk about some updates with the case with court hearings. So I want to give everybody an update in terms of some recent court hearings we had to keep everybody in the loop. I do think, as we will talk about, we took a big step forward forensically at this last court hearing, but let's walk through it. Okay. So the first update is we had brought a motion to appoint a new special prosecutor. The basis of that was that we thought Will County State's Attorney's Office just wasn't doing anything. They weren't interviewing our witnesses. They were opposed to all of our testing. They weren't really reviewing documents. So we brought a motion. As everybody knows, I posted that last time. We had a court hearing, and the court denied that motion. Now, that was not unexpected. It is a very difficult burden. You have to show an actual conflict of interest by the state's attorney, which I really couldn't show. But I thought the hearing was really interesting. I'm going to post on the Andy Hale podcast website a transcript of that court hearing from June 20th. I encourage everybody to go read it. If you want to really dig in and learn more of the details, I'm going to post this court transcript. You can read exactly what transpired at the court hearing. But there's some things, Whitney, I want to point out about the transcript.
Well, hey, Andy, can I ask a question just on behalf of our audience?
Yeah.
Can you explain the difference between a demonstrated conflict of interest and suspicion of a conflict of interest?
A conflict of interest is like, oh, you're the state's attorney and it's your cousin that got charged with a DUI. So, you've got a conflict of interest. It's typically something like that. It's like a family relationship. You've got a personal interest in the case. Mine was just a suspicion that something happened
Mhm.
that was causing James Glasgow, the Will County State's Attorney's Office, to back off. I still believe there's something that I don't know about. I did do a FOIA for Mr. Glasgow's phone records for the week period in which he told me the evidence was a complete disaster. He wasn't going to let me look at it. Will County hasn't given me those yet, but I'm going to pursue that. So we'll see. So it's a really hard burden. It's very rare that a state's attorney gets disqualified for having a conflict. But I want to go to this transcript. This was pretty stunning to me when I heard this in court. And I'm just going to read you what the Will County State's Attorney said in response to all my arguments about how they weren't doing anything. And they were first responding to, my woman who reached out about her grandfather, who said, he hired these, he was in the mob and he hired these guys. The mob hired, the husband hired these guys to go down there and kill the women, and her grandfather handpicked the men. All right, she says, well, I would respond that we don't take issue with whether she's telling the truth or not. She obviously told an employer of hers the same thing. I don't take any issue with Miss Smith saying this occurred. What the state's response is that it can lead to nothing. The grandfather's dead. All these people who would have had any information as to whether this was a 1960s mafia hit are dead. The grandfather's dead. I don't know what else. What other information Miss Smith could possibly allude to? Because again, I think she was 14 or 15 when these statements were made. The state can't really investigate the 1960s mob and go back in time and investigate the 1960s mob. So we don't take issue with Mrs. Smith's credibility. Okay, wait a minute. You can't investigate the 1960s mob. What are you talking about? I mean, that's what I'm doing.
Yeah.
Yes, you can. Go back and talk to people. Try to find documents. I mean, yes. What? You can't that would mean you can never investigate a cold case. Oh, everybody's dead. What can we do? Throw our arms up in the air,
But I mean, that's also just like saying, well, the entire academic discipline of historical research doesn't count because, once people are dead, we can't know anything. It's the truth is lost. There's no way to factually corroborate anything.
I just was so I really encourage people to read this court transcript. I mean, when I heard that in court, like, we can't investigate the 1960s mafia. I mean, what are you talking about? Yes, you can, you know? And she's saying, "Oh, we don't take issue with what Miss Smith said. We don't take issue with your credibility." Okay, if you believe what she said, then Chester Weger's innocent. Period. If you're not taking issue with her credibility, and if you're taking it as true, then he's innocent. I mean, I was just so flabbergasted with that.
I struggle sometimes, Andy, like reading this and listening to you repeat after I've read it, the logic, right? Or lack thereof. I mean, it's just Chester Weger's still alive. He was around in the 60s. Are there people living today that were alive in the 60s? I mean, I could maybe say, okay, ancient Egypt, 5,000 years ago, 2,500 years ago, 500 years ago. We can't know, right? That's just too long ago. But there are people alive who were, existing and functioning in the 1960s. This logic just, it blows my mind.
I want to bring up another thing on page 41. So basically, what Will County argued was, you know, it was the greatest hits from 1960. He confessed. The jury found him guilty, and it got affirmed on appeal. I mean, so the judge on page 41, he says to Will County, "Is it enough to rely on what happened in the 1960s?" And I love that. I love that question. It was exactly right. And Will County says in response, "I believe it's enough, yes, where we have not been presented with any valid information that would suggest the confession was coerced." Oh my god, it's like, have they not read anything I've given? The fact that he was trailed 24/7. The Illinois State Police literally followed him 24/7 for 4 or 5 weeks, that he was threatened with riding the Thunderbolt. I
Mhm.
mean, to say nothing that would suggest the confession was coerced, and how about the fact that he claims the murder weapon was the log, and we've shown that the log could not have been the murder weapon. I mean, oh my god, it's just hard to
Yeah.
understand how they could say something like that. Will County said, "Defendant has shown us nothing that would make us believe that we can't rely on what occurred in 1960." Really? Nothing? What about Mrs. Zelensek, the telephone operator? What about the Palmatier brothers? What about Lupe Cardenas? What about Mrs. Smith and Mr. Tyson? I mean, my God, it just I don't know what to say to that. It's just unbelievable. The other thing the court said I thought was interesting and denied my motion. This is on page 64. The court says, "This court is not an ethics court. I'm not here to make decisions about whether there was a violation of Illinois Supreme Court Rule 3.8, which is a prosecutor's obligation to seek justice,
Mhm.
not just convictions." The court just found that there was no conflict of interest. But I thought that was interesting. What the court was saying was, a lot of my argument really was there did Will County, violate their ethical obligation to seek justice, which the judge is right. The judge doesn't have jurisdiction to rule on that, but kind of left the door open on that issue. So I just thought that was kind of telling, that the way the judge said that. Okay, so that's the special prosecutor. So Will County is still in the case. We're moving forward together, whether we like it or not. That was the first update. The second update is, we just had a court hearing recently, and there were two big rulings that went in our favor. The first was, we had brought a second motion for forensic testing, which the court granted. Let me explain why this is important. What we requested was a two-step process. Basically, we identified, let me backtrack. You know how we had the hair on Mrs. Murphy's glove and we got
Yeah.
DNA and it's not
Mhm.
Chester Weger, it's a male profile? And Will County said, well, so what? Who could be anybody? So let's do more. Let's test more hairs. So we identified about 40 more hairs that are in slides found on the women, found on various parts of their clothing, or found at the crime scene on or near their bodies. About 40 of these slides. Now, we're not going to just take those 40 slides, send them all to a Bodie Technology to test. It's just not an efficient way to do it. That'll be too much time and money. So the first step is, the court is allowing us to do this. We're going to send all those 40 slides to Microtrace. And as if you recall, Microtrace are our experts, they're microscopists. They look at things under a microscope, they're world renowned. They're going to try to identify hairs that they're going to compare those 40 slides, the hairs, to known hair standards of the women. Try to find hairs that look like they did not come from the women, that have roots and could be tested for DNA. And I'm hoping after that process we can identify, at least a few, if not, 3, 4, 5, 6 hairs that we can then send to Bodhi Technology to do more DNA testing. If you remember, back in the day, there were newspaper articles saying it looked like they had found at least 2 types of hair at the crime scene, like a
Mhm.
light colored hair and a dark colored hair. So I thought this was a huge development that we're going to potentially, we're going to send these hairs to microtrays. And I think we're going to hopefully identify some more hairs that we can test for DNA. And then there's a second part of that motion. Do you recall how in Chester's interrogation they asked him if he urinated on any of the women, if he
Yeah.
defecated on any of the women? Clearly, they had a basis to ask those questions. Mrs. Murphy's autopsy said she had soiled clothing. We don't have much of her, Miss Murphy's clothing. Very little. I think just her gloves. We've got more clothing of the other two victims, Mrs. Oding and Mrs. Lindquist. But the judge gave us permission for Microtrace to look at all the clothing we've got, to look at it under a microscope to see if there might be microscopic evidence of urine or feces, some kind of a stain. It's a long shot for sure, but if we find something like that, we can then test that stain for DNA. So I thought that was a really big step forward because we are now going to be in a position to potentially develop more forensic evidence in the case. And I've always felt like that's how we're going to break this case open forensically. You know, you and I can argue till the cows come home about, all the things that we've talked about in this podcast, the last 20 episodes. But the forensics, I think, are what are going to drive the nail in the coffin.
Logic and, sort of common sense just haven't seemed to sway anyone. I think you're right. I mean, it's just it's going to take some sort of irrefutable scientific fact, and I know that day is going to come, and I'm just, I cannot wait until we can get some sort of identifiable piece of evidence that's gonna blow everything open.
And so, just so people know the timeline, so this evidence, we're going to be going out to the LaSalle County Sheriff's Office probably in the next week. Microtrace is all the evidence is these 40 slides that have hairs in them that are all labeled are going to be taken to Microtrace, where Microtrace is going to look at it all under various types of microscopes, a very sophisticated, non destructive microscopic analysis. That's all going to happen in August. So I'll keep everybody posted in terms of how the progress with that goes. And like I said, hopefully we can send it to Bodhi Technology for the second part, which is DNA testing. All right, but here's the part I think I'm the most excited about: genealogy. So that hair that we found on the left index finger of Mrs. Murphy's glove, that we got a DNA profile, it's not Chester Weger, it's a male. That's the same finger where her fingertip was cut off. We're going to be able to send that hair extract to a lab in Texas called Othram, Othram. They are a leading laboratory, one of only a couple that does this kind of genealogy work. And the court granted our request to do this. And what has to happen is the Othram people, their lab people, will do genetic sequencing of that hair extract. Hopefully, okay. There's a chance, that they may be unsuccessful, but they think they've seen all the data. They think they can do it. They first develop a genetic profile, and then once you get that genetic profile, you then build up the family tree using genealogy databases. And you try to basically, at the end of the day, find out who is the source of that hair. Can you imagine if someday we can say that hair on Mrs. Murphy's glove came from boom, whoever?
I feel like that day will come. I feel like that day will come, and I am dreaming of it. I honestly, Andy, I think about it maybe twice a day.
Oh my
I
gosh.
no, I mean, honestly,
Yeah.
I'll just be at
Yeah.
the grocery store, and it will just suddenly hit me that, like, that information can be found, right? We live
Yeah.
in a time when science can glean that information, and I just it honestly crosses my mind probably twice a day.
Well, the way this came about was, Bodie Technology was trying some genealogy on their end, and they were having some difficulty with it. And this was just a few weeks ago. I was reading the Sunday New York Times. It was a big front page article about the Idaho murders,
Mhm.
those
Yeah.
four college students that were killed in Idaho.
Yeah.
And it talked in this article about how the local police teamed up with Othram, this lab in Texas, because they had found some DNA, I think, on a knife sheath that was left in the house. And they were able to, I think, get some DNA, develop a profile, and it all led back to this young man who's been charged. But they used genetic genealogy to kind of crack the case. And I think, like I've said this before, I think it'd be really fitting for a 1960s case to be cracked with this cutting edge 2023 genetic technology. That would just be so fitting. Now, um, just so everybody gets a time frame for that, Othram has told me it takes 12 to 16 weeks to do the lab work, which is to kind of basically do the genetic sequencing. And then the genealogy part just depends on what they can see in the
Yeah.
genealogy databases. They said it could take a week, 2 weeks to a couple months. So
Yeah.
we're looking basically at 5 months, probably minimum. So I'm hoping that maybe by the end of the year, we are getting close and maybe we have an update. But I'm super excited about the possibility that Othram can identify through genetic genealogy the person whose hair is on the left index finger of Mrs. Murphy's glove. That could be the final piece of the puzzle that we need. And I just thought with the court allowing us to do both those things,
Yeah.
to both, look for more hair evidence to test for DNA and to send this one particular hair to Othram, we took a huge step forward with our forensic investigation. We now have the opportunity to do these things.
It's incredible. At the risk of sounding like my grandfather, here, he used to say, "What a time," right? What a time we live in that this is possible because had you been trying to do this 25, 30 years ago, these doors would have been closed. These would just not have been options on the table.
No, exactly. We'd have been out of luck. So, and I want people to know I'm still investigating. I'm still trying to talk to people in the Illinois Valley area near Starved Rock State Park, especially older people that were around back when the Starved Rock murders happened. If anybody knows anybody like that, please reach out. I would love to talk to anybody. If it's your grandmother, grandfather that might know something, even if it's anecdotal, it all helps. We also, just one other little update, the Will County State's Attorney's Office had interviewed James Murphy a while back, who they had asked to do a DNA test to see who his biological father is. And he to date has declined to do so. So we wanted to know whether his biological father was Robert Murphy, the husband of Frances Murphy, because if it is, that's significant because that would mean he fathered a child with the woman he married 2 years later. It all kind of jives with, a lot of the evidence we put together. So I'll keep everybody updated on that. One last topic. I want to talk a little bit more about John Reid and the polygraph. And this is something, it's kind of an area that, I mean, most people don't know much about. There's no reason anybody would know much about it, which is the polygraph exams. And going back to 1960, I want to just explain. I did a little more research on this issue because I think the response we get today is, "Oh, Chester Weger confessed. He's guilty because he confessed." Right? He failed the polygraph and he confessed. What people don't realize, it's a lot more complicated than that. And let's pause. Chester passed the first 6 polygraphs given by the Illinois State Police. It wasn't until months later he's taken to Chicago to this guy, John Reid. John Reid was a former Chicago police officer who developed this polygraph technique that was very controversial and it still is controversial. And it had a very confrontational aspect to it. It's not like you just go in a room, take the test, and you're out in 15 minutes. There's a whole process where, you kind of basically, grill the person and kind of get in their face. And it's very controversial. I'm going to post on the website. I want people to read this. We retained an expert named Brian Cutler on the issue of false confessions. And I'm going to post there's Mr. Cutler has a whole section of his report talking about how John Reid developed this technique, why it's controversial, the way it's accusatory, it's guilt presumptive technique. And I want people to read this, because it's really interesting. I don't want people to think like, oh, he confessed to John Reid. Yeah. Well, okay. It was a very controversial technique back in the day, and it still is. And here's the part that I found the most interesting when I was doing a little more research. I found I found some old cases of false confessions that John Reid obtained. Okay. I'm going to post this on the website too. I want everybody to read these articles. The first one I want to talk about was in 1955. There was a guy named Daryl Parker. This case, I believe, was in Iowa. His wife is found murdered. He becomes a suspect and winds up confessing to John Reid, but then recants soon thereafter and claims he was threatened and kind of coerced. Well, years later, there's a guy who confessed, who was some kind of handyman and confessed to the murder. And Daryl Parker got exonerated and received compensation from the state of Iowa. So in 1955, you know, it's an example of John Reid getting this young guy in his 20s to confess to killing his wife when he didn't, when he didn't kill her.
And the Reid technique was utilized in obtaining the confessions for the Central Park 5 too. I mean, not John Reid himself, but that technique. I mean, it's infamous.
Yes, it is infamous. It's exactly right. And so I want people to know that. And here's another stunning case I found when I was just doing a little research. And like I said, this is just me poking around. It wasn't like I did some exhaustive, thorough, let's spend a
Sure.
whole month doing this. In 1958, okay, so this is 2 years before Chester Weger and the Starbuck murders, there was a fire at a school in Chicago that actually tragically, I mean, 90 people died.
Mm.
90 people died in this school fire. I hadn't even heard of this case. Well, then at some point later, there was a tip that this young boy, this like 13-year-old boy, who had set some other fires, smaller fires, may have set this fire that killed these 90 people, students and nuns at this Catholic school. John Reid gives him a polygraph, and the boy confesses. The boy confesses to John Reid to
And
setting this fire.
how old is this boy again?
I think he was 13.
Oh, wow.
And yeah, he was 13. And guess what? He had a trial then. Okay. The case went to a trial, and the judge refused to the judge basically did not believe the confession that he
Mhm.
gave to John Reid. Let me read you part of an article. And again, I'm going to post this on the Andy Hill podcast website. Please read these articles. The judge said that the confession to the school blaze was contradicted by all the circumstantial and physical evidence which was adduced in open court. I mean, the judge noted that the boy's story was contradictory to everything that had been said about, the actual physical evidence. The judge observed that the only similarity to known facts about how the fire started was the boy's statement that he set fire to a cardboard trash barrel with metal rims in the basement. The boy, however, said the barrel was under a staircase, while Sergeant Brown and Chief James Kehoe of the Fire Arson Squad testified earlier that it was at the foot of the staircase. Other discrepancies in which the boy's confession did not jive with the actual physical layout. And he also said he was critical of Reid's methods during the 7-hour session. How is this a polygraph when you're 7 hours with a person? It's not a polygraph, it's an interrogation. And he
7
said he was,
hours with a child.
yeah, he was troubled by what they did. And his representation of the boy that he needed to sign every page to make sure his file was complete. I mean, so the judge didn't even give it any weight, and he
Wow.
acquitted this boy of setting this fire. And also, one last thing, the famous Miranda versus Arizona decision, which I'm going
Mhm.
to post on the website too, in 1966, which basically said, you have to have be told that you have a right to an attorney. Everything
Mhm.
you can say could be used against you. At several points in that landmark opinion, the court is critical of the Reid technique. At several points in that opinion, and my expert Brian Cutler talks about that in his opinion. So I've dumped a lot of kind of technical stuff on everybody out there, but for those who like that kind of stuff, you want to read, you're interested in some of the law, some of the facts, you want to take a deeper dive, go to andyhalepodcast.com, go to this website episode. I'm going to post it all there. You can read about Brian Cutler's report, his criticisms of the Reid technique, the Miranda decision, the Daryl Parker case, this 13-year-old boy who falsely confessed to John Reid over this fire, in 1958. So I thought that was pretty stunning to read those things about John Reid extracting those false confessions from other people back at the same time frame as Chester Weger.
Yeah. I feel like, when I've read the tactics employed by John Reid, I've thought to myself, I would have confessed to anything to make it stop. Right? Just the
Right.
just capitalizing on fatigue, right? Just basically, like you said, 7 hours or longer in other cases, just relentlessly hounding a person to the point that, like, I could see myself breaking just to make it stop so I could just go, like, take a nap and, like, recover and just go, "Yeah, yeah,
Yeah.
yeah, sure, sure, whatever you say."
And so in our case, if you remember, Chester Weger, he goes to Chicago. He doesn't confess to John Reid. Like, he
Yeah,
was with him all day. They
yeah,
try to break him. He's there all day. And even riding back, they're threatening him with, the electric chair. It's finally then after that next month when they follow him, surveil him 24/7, then arrest him without probable cause, say he's going to basically, get the electric chair. They finally break him down and he confesses. So everybody needs to really look closely at the circumstance of Chester Weger's confession because as we've said, and I'm a broken record, all the hallmarks, all the factors of a false confession are present. That's all they had. It's inconsistent with the physical evidence. The story makes no sense. And I go back to Will County saying we've given them no evidence, any credible evidence that Chester Weger is innocent. It's like, oh my God. Have you not looked at those 75 pieces of evidence that I laid out in that 10-page letter I sent to you? So, anyway, Whitney, that is the update. I'm excited about the forensic possibilities that await us. We're going to be on this forensic journey for the rest of the year. And I will be sure as soon as I get an update or result, our listeners will be the first to know. We'll be back on this podcast with an update. But I'm so glad we're getting a chance to forensically do more because that's ultimately going to be what is the final puzzle piece.
yeah. It will happen. I have perhaps a Pollyanna view of this, but I just feel like the science will prevail in the end and the truth will come out.
I feel the same way. I feel the same way. All right, we'll be back in touch. Stay tuned, everybody. Thanks for listening to this episode of the Starved Rock Murders. This has been such an incredible journey, but we are not done, not by any stretch. Please visit our website, as I said, andyhalepodcast.com. We're going to be posting documents and all kinds of things of interest in the case. If you know anything about the Starved Rock Murders, please email us. No information or tip is too small. It all matters. We really need your help. And if you know of anyone that you think was wrongfully convicted, if there's another Chester Weger out there, reach out. I'd love to hear about that as well. If you enjoyed today's episode, please subscribe, rate, and review us wherever you get your podcast. Your reviews and ratings mean so much to Whitney and me. This episode was produced in collaboration with Phineas Ellis and Studio Friends. Design, content, and promotion by Bell and Ivy, and hosted by myself and Whitney Braun. We'll see you next time.